for those of you who are waiting for the webinar to start, I'm getting some questions here asking if it started because folks can't hear anything. You should be able to hear this if you have your computer set up right. We'll be starting in just a second here. Okay, Ben, we ready?
We are ready.
Okay, so thank you everybody for calling in to listen to our webinar today on loaning firearms. If you look at this first slide here, you can see the questions that you can post questions in the box on the lower left-hand side of your screen. I will try and answer some of those as we go through, particularly after I turn it over to my associate. But it's very difficult to answer all those questions. Typically, that's been the experience, at least in the previous webinars that we've done. But we'll do our best, and at the end, we'll try and circle around and collect the ones that have been asked the most and answer those at the very end of this particular webinar. The other webinars that we've done on all the new state laws are posted at crpa.org/webinars, and that includes the webinar on Prop 63, which I hope that you will all vote against and get all your friends to vote against. And maybe if they need to know what it does, they can watch that webinar. All those webinars are free. And this one, after we finish it, it's being recorded and it will be posted too. So today's webinar is on lending firearms in California. Some of the recent changes in legislation have prompted a lot of questions about whether or not some of this lending has been restricted and to what degree. So we're going to clarify that for you today. I'm Chuck Michelle. I'm the Senior Partner at Michelle & Associates. With me today on this call is Joe Silvoso, our Regulatory Compliance Counsel at my firm. And he is also the co-author of our book on California gun laws, which I'll talk about in a second. One of two of the biggest clients that my firm represents are the California Rifle and Pistol Association and the National Rifle Association. I'm also the volunteer president of the California Rifle and Pistol Association, working pro bono to try and stop further erosion of gun rights in California. So the objectives for today's webinar are to go through the general rule prohibiting firearm transfers except through a licensed dealer. That is the general rule. And there are several legal exceptions to that general rule for loans to firearms. And there are more specific exceptions for loans of firearms to minors. And that's something that there's been a lot of concern about, the junior programs, junior shooting programs, and mentoring and training type programs. So we're going to talk about those too. But before we get to that, I have to do the lawyer weasel words. Please forgive me. There is no attorney-client relationship created by this webinar today. I would think that'd be obvious, but some folks don't necessarily understand that. You shouldn't post anything on the questions about an individual specific situation that you may find yourself in, because unless you do this under the auspices of a consultation with my office, it's not attorney-client privileged. So please, I've had some folks put the things up there about things they've done that I just don't want to see anybody getting in trouble. So, and also we're providing this information to you as we understand it and as we read the law. But keep in mind, the judges in California, generally speaking, I think it's fair to say, are hostile to the Second Amendment and generally to gun owners. There's a lot of judges and a lot of prosecutors who don't understand the difference between a good gun owner and a bad gun owner. They don't understand, especially some of them don't even, they don't know the difference between a semi-automatic rifle and a sharp stick. So you can't count on them interpreting it the way we think they should interpret it, although We've been doing this for a long time, and we're pretty good at it, predicting what they're going to do. So the California Rifle and Pistol Association, I hope you'll all consider joining. We're doing a lot to try and turn the tide in California and stop the erosion of our right to keep and bear arms. We could use volunteers. If you have a general comment or question, send it to contact@crpa.org. More information, go to their website, but just for sort of general information, these are the type of things that the NRA and CRPA do together in California. They have lobbyists up in Sacramento. They do local ordinance, gun control ordinance monitoring, and submit oppositions. We're working in several jurisdictions right now to stop local cities from increasing the cost of applying for a concealed weapon permit, a license to carry. We're working in Del Mar to try and oppose them talking about shutting down the Del Mar gun show. We protect ranges all across the state. We do hunting regulation and petitions. The animal rights movement, so-called, is made no secret of their intention to ban hunting in California by 2024. Their idea is to let the coyotes, mountain lions, grizzly bears, and other predators eat the deer and elk so that hunting is not sustainable or necessary. We also watch the California Firearms, the California Department of Justice Firearms program, and make sure that they don't overstep their bounds with regulations that make it more difficult to get or own or use a gun. With Kamala Harris in charge of that, that's a constant battle. We do shooting programs all across the state. Anything we can do to get people out pulling triggers. The more people who shoot, the more people who are available to help fight against people who don't want you to be able to shoot. Do training programs for all demographics and ages. Grassroots volunteers and members, NRA members councils across the state are part of the activists that are involved, and so I encourage everybody who's willing and able to get involved in those. We're also involved in elections and campaigns. We're really stepping up the efforts on this in response to Prop 63, and of course we do lots of right to keep and bear arms litigation, and all of the laws that passed this session are subject to legal challenge. The NRA and CRPA have already approved that effort, so they will be filing lawsuits against anything that is challengeable. I expect we'll see a lot of challenges to the DOJ regulations, whatever they may be, depending on how they interpret their ability to pass those and how they try and characterize certain or mischaracterize certain firearms. But if Hillary Clinton gets elected, there's going to be a very hostile Supreme Court, so it's going to change the dynamics of Second Amendment litigation fairly profoundly. She will stack that court with with judges appointed by Democratic presidents who have already done everything they could to gut the Second Amendment in the Heller case. So this is a pretty critical election. I hope everybody on the call already is aware of that. So with that, I will turn this over to Joe Silvoso. Let me just say before I do that, there are some DOJ webinars which are coming out for firearm retailers. You might want to check the DOJ website and see what they're making available. Hopefully they will be watching and to make sure they say it right. I also want to let everybody know that the CRPA and NRA have worked very hard under the umbrella of the Coalition for Civil Liberties, which is a political action committee that's been fighting Prop 63. A nonprofit entity like CRPA or NRA is limited in how much money they can donate directly to a political campaign, because if you donate over $50,000 in any single year, then the members and donors to the membership association have to be disclosed. Well, obviously, CRPA and NRA members don't want their information disclosed, and that's something that CRPA and NRA guard very, very zealously to make sure it doesn't get disclosed. So it has to be done through this PAC. That way people who are donating to the PAC know what information they're providing, personal information they're providing, and know that it's being disclosed. So the NRA has done lots of member communications to the various to their membership bases and ask those people to donate directly to the PAC. So there's been a lot of misinformation out there about how much NRA has actually and CRPA have actually contributed to fight the Newsom packet, it totals up to about $2 million, despite what the press is reporting. So they've been actually very involved in that. And that political action committee is going to survive Prop 63. So you'll be seeing, if you're a member of the NRA or the CRPA, and I hope you're a member of both, you'll be seeing more communications from them about a political action plan that will be coming out for the next couple of years to try and revive gun rights in this state. And nothing is off the table in that, but we'll be firming that up in the near future. Lastly, I think I'd ask that each of you, I apologize to those of you who didn't like the polling questions that we had originally put up in the front. You had to fill out those polls in order to be able to register for the webinar. I was trying to take the polls out of the webinar itself because they took up some time and people were trying to get it finished as quickly as possible. But some folks didn't like the idea of us asking those questions. I understand that. So now the polls will be emailed to you. The polling questions will be emailed to you after the webinar is completed. I do ask that you please fill out those questions. We're trying very hard to figure out the demographics of the gun owning in population in California. There's something between 8 and 12 million gun owners in this state. If they all engaged and voted, we would basically control the California politics. So gun owner engagement is something we've been working very hard to increase, and hope all of you will help us accomplish that. One way you can do that is to give us some of that information. We don't keep the information relating to any specific individual. It's all aggregated so that we just try and get an idea of who's listening and what their interests are. I think that's it for me for now. So Joe, I'll turn it over to you.
Okay, sounds good. Thanks, Chuck. And yeah, as Chuck mentioned before, and coming up with this webinar, I was, and I think we were, surprised at the number of questions we got concerning the loan bill and the confusion it caused, and people believing that they couldn't loan a firearm while they're hunting to a fellow hunter, whether or not when they're in their home they can just show a firearm to a friend of theirs to check out, or while at the range, loaning a firearm to somebody while you're at the range. And for the most part, all of those exceptions to the restrictions on loaning firearms in California have remained in place. The only real change to the law has been the one we'll discuss here pretty soon. And as a result of this confusion, we came to the conclusion that maybe a webinar specific to the loan issue was going to be needed. And so here we are. We do talk about loans in, I think, our last of the 3 webinars on the bills that passed prior to the Newsom webinar a bit, and I touched on that confusion as well just a bit. But nevertheless, we're going to go a little bit more detail into the loan restriction and then exceptions to those to that restriction. For most people, I'm not going to go into a lot of detail, and you'll see the list of exceptions for loaning when it comes up. I'm not going to go into a lot of detail on some of the less common ones. I'm never going to find myself on a movie set. I'm not a member of law enforcement. And so we're not going to go into detail on those, but we'll touch on a lot of the common exceptions. And last but not least, a lot of concern was raised with respect to the youth groups and the loaning of firearms to the kids who are shooting, either earning merit badges or 4-H club or the Girl Scouts when they get out there on the range. People who run those programs, participate in those programs, even provide firearms to those programs, they having concern with respect to the loan restrictions and requirements in California. So we touched upon that as well in a bit. But the first slide, what you have in front of you here, is the general restriction. And keep in mind that when 2 individuals reside in the state of California and either one of them have a California dealer's license, the sale, transfer, or loan of that firearm must go through a licensed firearm dealer. As with anything under the law, and especially California gun law, there are exceptions to that restriction. And like I said before, we'll talk about those exceptions to the loan restriction in a bit. And like I said before, there are a lot of exceptions to all of those general restrictions. There's penal code sections on the screen right now that a lot of those exceptions we're going to be talking about may be found, I believe, on each and every single one of these slides that are coming up, at least on the list of slides. For all those exceptions, we'll give you the exact code section that is discussed for that loan exception. And there they are. We have a lot of exceptions to the restrictions on loaning a firearm through a licensed firearm dealer. And as you can see from those first 2, They relate to law enforcement, either law enforcement representative of an agency loaning it to an officer there, or representative of the agency giving it to a museum. Again, I'm not a museum. Most of you, I'm sure, listening are not as well, or representatives of a museum. So those first, second, and third slides don't really apply to probably, if not, I dare say, all of us on this webinar today. The next exception is the one that was changed as a result of this the bill this past July. The personally known exception, and I'll talk about what that was changed to and the restrictions and the requirements for you to avail yourself of that exception. And then some of the other exceptions that are still California law, the personally present, the target facility, the long gun loan for hunting, loaning to kids by parents and guardians, and loaning to kids by people not associated with them. And then last but not least, those last two, movie props and licensed collectors. I don't assume that we have too many licensed collectors, although the people who are chiming in on this one, I might be surprised by that. But nevertheless, we'll not talk or not have to go into great detail concerning movie props, because unfortunately my acting career didn't pan out the way I'd hoped, or at all. And the last but not least, the licensed collector. We're not going to be going into that in great detail. So for the people here on the webinar, as of today, the 6 exceptions that are going to be most pertinent to all of us, and again, the personally known exception for number 1, the one that's changing, and then of course the ones I already listed, the personally present, the hunting season, loaning at ranges, the loan of firearms to children or grandchildren, and the loaning of a firearm to a minor. We'll talk about those in more detail. And starting things off, the personally known exception, like I said, this one will be going away as a result of the bill that was passed this last July. This is current California law, but it will be over and done with come January 1st, 2017. However, as of at least right now, if you personally know a person and you loan them the firearm for a lawful purpose, you can't just give it to them for a drive-by or a 7-Eleven holdup. You have to do the loan infrequent, and infrequent is defined at the bottom of your screen. The loan can't exceed 30 days, and the recipient needs to have a firearm safety certificate, or if the firearm is a handgun, you may still be able to use the handgun safety certificate for purposes of the loan of the handgun only. And then also keep in mind that the firearm safety certificate and the handgun safety certificate require you to be 18 years of age or older, so you cannot avail yourself of this exception for a person who's under the age of 18 because they can't get themselves a firearm safety certificate, or if they still can have one, a handgun safety certificate. And then like I said, these loans would need to be infrequent, meaning that you'd have to do it less than 6 times in a calendar year for handguns, and for all other firearms, it's just occasional without regularity. I still don't know what that phrase necessarily means. You just want to be mindful of it and don't do loans of long guns or firearms other than handguns, meaning rifles and shotguns, a lot, let's just say, because that term and phrase is not defined by California law, and I dare say the courts haven't gone into that definition as well. Moving on to what the exception was changed to, as of January 1st this coming year, you're still going to be able to loan firearms under this exception. However, you're going to be limited to whom you may loan the firearm to. You see, the infrequent is still there, and so these loans have to be done infrequently, but the loan has to and can only be made between spouses and registered domestic partners, and then certain members of your family. Between parents, children, grandchildren, grandparents, and then siblings. That siblings is an interesting addition. You don't see that used as often as I would prefer, and specifically there's an exception to the transfer restriction amongst immediate family members. The sibling exception is not there. So if you wanted to outright transfer a firearm in California between 2 individuals who reside here, presuming they can own and possess and receive firearms, that relationship is only between parents, grandparents, children, grandchildren. They, for purposes of this exception to the loan restriction, added siblings, which is nice, but nevertheless, no aunts, uncles, cousins, and things like that. It's going to be close members of the family tree. again, the loan is going to have to be for lawful purpose. Again, it cannot exceed 30 days. However, an added wrinkle to this exception for the loan restriction, the handgun needs to be registered. A lot of people will just assume that their handguns are registered to them. That's often not the case. If you didn't purchase the firearm or the handgun through a licensed firearm dealer, you acquired it through some other mechanism at a time that you didn't have to go through a dealer or register the firearm upon receiving it, the handgun might not be registered to you. And even in certain circumstances where you've acquired the handgun from a licensed firearm dealer, you may not necessarily have that firearm still registered to you. The dealer might have erred in how that information was put into the system and into DOJ, depending on how long ago the transaction occurred. If the transaction occurred prior to the electronic system, those records are not that great in the automated firearm system. So if you have any questions or concerns about whether or not a handgun is registered to you, and keeping in mind that a handgun doesn't need to be registered to you to lawfully possess it for most intents and purposes, and one exception to that statement I just made I can think of is if the firearm is an assault weapon, it's not illegal for you to possess. And so sometimes law enforcement is confused concerning what the requirements of a registration are for owners of firearms in the state of California, but it is not a crime for you to possess or own a firearm that is still not in the automated firearm system or registered to you. But nevertheless, there is a form you can fill out and send into the California Department of Justice to ask them to give you a list of all the firearms that are registered to you in the automated firearm system. That form can be found at the California Department of Justice website, Bureau of Firearms, under the Forms and Publications section. You fill that out and you send that in, and DOJ will send you out over a period of time the list of firearms that are registered to you. And then last but not least, and as I discussed before, for this exception, as with the personally known exception, you have to have a firearm safety certificate to receive the firearm, or if the firearm is a handgun, an unexpired handgun safety certificate. I didn't mention it before, but it bears mentioning now. No more handgun safety certificates are being issued. It's only firearm safety certificate. Handgun safety certificates were valid for 5 years from date of issuance. And so come 5 years from after January 1st, 2015, when handgun safety certificates went the way of the dodo, and we're dealing with only firearm safety certificates. Somebody got that handgun safety certificate on December 31st, 2014. They'll probably be one of the last people who have a valid handgun safety certificate in the state of California, until having to go out and get a firearm safety certificate if they want to purchase or be lent any more firearms in the state of California. But don't panic. There are, and there still remain, as I've mentioned before, a number of exceptions to the loan restriction that I've discussed here, and especially for those who are concerned about the modification of that personally known exception and it going away and requiring, as of next year, a family relationship to that exception. There are and there remain a number of other exceptions to the loan restriction. First and foremost, you have one of those situations where you're on a shooting range. Of course, that shooting range has to be licensed business or has a regulatory license, and you got to keep the firearm at the range. And so if two people are at a range, and of course assuming everybody can own and possess firearms lawfully, you can loan somebody else a firearm, no firearm safety certificate required, none of that family relationship required. But just keep in mind, you got to be at a licensed facility, and you got to keep that firearm there. So if your buddy shows up at your house and says, "Hey, I'm going to the range. Can I borrow your rifle to shoot off a few rounds?" The answer to your question is no in that situation, unless your buddy is an immediate family member. But if you accompany your buddy to the range, or you see your buddy at the range and say, "Hey," and he says, "Hey, I really like that gun you got. Can you mind if I squeeze off a couple rounds?" Sure, no problems there, provided you're at a licensed range. And how do you know if you're at a licensed range? Well, ask. And anybody from a range who's listening here, if you would be so kind as to potentially post your license somewhere that's visible so people who are concerned about this exception and the nuances to this restriction can figure out whether or not there's a license present. Or if you can just post somewhere, "Yes, we are licensed facility, so those people who are participating at the range don't have that area of concern when it comes to this exception to the loan restriction. Another one is for the licensed hunters. Long guns only for this one, unfortunately, licensed hunters. So handguns will not work in this situation, but you may do a loan of a long gun as long as the loan does not exceed the duration of the hunting season for which that firearm is going to be used. And so if you have a friend who wants to come by your house and say, hey, can I borrow your rifle? It's deer season and I want to take it out and mine broke, jams in the shop. In that situation, you may loan the firearm, the long gun, to them for purposes of hunting, but make sure and just confirm that the person to whom you're loaning the firearm has a valid hunting license. And so in that instance, you're going to be able to neatly fall in to the exception for hunters. Loaning another firearm to a person with you being personally present, and this is not necessarily needed for the range, but if somebody comes by your house and they say, hey, I want to check out your firearm, well, great. You can go ahead and loan them that firearm for them to look at, but you need to remain personally present while that loan is taking place. Again, it has to be for a lawful purpose. So if you loan somebody a firearm for purposes of going into a 7-Eleven, that's not going to quite work if the plan is to rob the 7-Eleven. Make sure, of course, or know that the person is not prohibited. These types of loans cannot exceed 3 days, and much like one of the previous other loan exceptions I mentioned before, the person has to be over the age of 18, and you yourself have to be over the age of 18 to avail yourself of this loan exception. But this is going to cover you in a lot of other situations where you are present and someone wants to see your firearms, handle your firearms. If you're not at a licensed range, that'll cover you there as well. But nevertheless, this restriction is for those only over the age of 18. There are a number of exceptions for minors that I'll talk about here in a second. But for this exception to apply, you, the loaner, and the loanee both need to be over the age of 18. While we're talking about loans, and since we're going to probably have a whole bunch of more firearms meeting the definition of an assault weapon next year, we thought it would be a good idea to throw in this slide. For most intents and purposes, all of the exceptions I mentioned before are not going to apply to firearms meeting the definition of assault weapons and 50 BMG rifles. You are limited to whom and how you may loan those firearms. If your friend were to show up and want to borrow your registered assault weapon to take to the range, or they're a family member who wants to take the firearm someplace else and you want to loan them that firearm in that situation, and by that firearm I mean a registered assault weapon, that's going to be a no-go unless they are also a registered owner of that firearm, because for purposes of this limited exception when it comes to the loaning of assault weapons, you can only loan that assault weapon or 50 BMG rifle. But I'll just, so I don't have to say both of them every single time, I'll just mention assault weapons from here on out. If you want to loan that assault weapon to somebody else, first of all, that person has to be over the age of 18. I've had it, and our office has had it on more than one occasion, parents being irate and contacting us because they got kicked off of a range because they were having their son or daughter who is under the age of 18 shooting their registered assault weapon at the range, and the range master said, hey, sorry, you can't do that here. That minor cannot be lent that assault weapon, and that's specific, and they're actually correct because of the restrictions relating to the loaning of assault weapons and the requirement that you do so over the age of 18. Of course, the registered individual has to be personally present when that firearm is in the hands of somebody else. And then last but not least, you're limited to where you can make those loans, and those exceptions are located there. You've got your licensed ranges, you've got your clubs, and or you're attending a exhibition or display, or for educational purposes, that firearm is being used. And so you are further limited when it comes to firearms meeting the definition of an assault weapon, where and to whom you may loan that firearm, or you got yourself some huge problems when it comes to, well, the person you're loaning that firearm to, if they leave your presence, they are now in possession of a firearm that's not registered to them as an assault weapon. they could be charged conceivably as in possession of an assault weapon. And then you have a problem because you have either transferred the firearm to them or caused them to become in possession of it. And so you yourself may have a bit of a problem in explaining to your defense attorney as to what happened and why that happened. So keep those in mind. And like I said before, we're going to have a lot more firearms, meaning the definition of assault weapons, come next year as a result of the other bills. We do have that webinar on assault weapons, and so we're not going to be addressing any assault weapon questions here. And all of those, a lot of questions are addressed in that webinar. And then as Chuck mentioned, all of this information and all the information in the past now 4 webinars that we've gone over are going to be located in the California Gun Laws book. Prior to calling in for this webinar, I was revising Chapter 8 of the book having to do with assault weapons, and specifically the part where we're talking about registering firearms, meaning the definition of an assault weapon next year. So that's going to have a lot of information, even more detailed than we're going over here today, for you to look at and review. And then, of course, and last but not least, if you have further additional questions, you may reach out either to the CRPA or to our office if you want to retain counsel to address questions that you may have, or, of course, and God forbid, you come under any legal scrutiny or pressure from law enforcement or anybody else relating to your possession, loan, transfer of that firearm. And moving over to the Utes, as they are, there are both federal and state restrictions to keep in mind when we're talking about kids possessing firearms. And so you need to be careful of both. Quite often people, when they're looking into laws, will focus on one and not pay too much attention to the other. And so when you're always making sure that you're following the law when it comes to anything in relation to possessing, owning, selling, transferring firearms, make sure, especially in California, you not only check federal law, but most certainly follow up on the California requirements when it comes to any of these activities. And the loaning of firearms to minor is not an exception to that, because there are restrictions under federal and state law, and they don't exactly line up straight together. And I'll talk about that here as well. I would love to be able to say that if you just follow one of these, you're good to go with the other. Not so much, and you're going to need to be very careful that you follow both of them in moving forward. First and foremost, there is no long gun restriction when it comes to at least loaning a minor a long gun and or the minor being in possession of that long gun. California has a restriction on both handguns and long guns. Federal law, for purposes of just the loan that we're talking about and the possession by the minor, there is no law restricting that activity. The handguns and handgun loaning come into effect under federal law as well. And forgive me for half a second while I play with my computer that seems to have gotten anger at me. There it goes. The handgun restriction, there is a handgun restriction for minors and an ammunition restriction for minors, but that restriction is for ammunition that is suitable for use only in a handgun. That term is both poorly phrased and dangerously broad when it comes to federal law and the federal restrictions. But nevertheless, there is a restriction on both minors possessing handguns and then the ammunition that it is suitable for use only in handguns and the loaning of those two items to the minor. However, there is an exception, and it's for the temporary. And again, the feds aren't too great in telling us what temporary is, just like California wasn't too great in telling us what infrequently is for long guns. But nevertheless, there is an exception for the temporary loan and the temporary possession of the handgun and that ammunition by the minor, but only in certain circumstances. You're going to have requirements as to how and where that firearm is used, and that list is right there. If it's in the course of the minor's employment, ranching, farming, target practice, hunting, and firearm training, the minor's parent or guardian has provided written consent for the minor to possess handguns and the ammunition the minor needs to keep that written consent with them at all times. And then, of course, you're going to be subject to and need to follow the state requirements as well. Keep that written consent requirement in mind because, unfortunately for us, federal law doesn't appear to contemplate at least a common sense approach wherein if a parent is standing over a minor child showing them how to shoot the handgun, why in the world would you need written consent with the minor's parents just standing over them? That would appear to be a problem and an issue under federal law. It's not specifically addressed or contemplated. It would be assumed that that situation should be all right. I've never had a case, or our office has never had a case, where anybody has been prosecuted or looked into that type of loan. But nevertheless, in situations under federal law, for that minor to be loaned a handgun, you're going to need written consent from the minor's parent or legal guardian. And under California law, we have ourselves a little bit of a different situation. And we'll start with the long guns because, like I said before, while federal law doesn't restrict the loan and the possession of long guns to minors, California does. However, again, there are exceptions to that loan restriction. A parent or legal guardian can loan a long gun to their child without going through an FFL and no other issues with respect to that loan. Grandparents can loan a long gun without going through that FFL. However, you need the express permission of the minor's parents. We don't have a good definition or any definition for purposes of this loan exception to what that express permission means, but nevertheless, it's not specific concerning what exactly is going to be required for the parent or guardian to give express permission, and then any other individuals may loan a long gun to a minor with the express permission of the parent legal guardian again. The loan needs to be for a quote-unquote lawful purpose, and the loan cannot exceed 30 days. So grandparents could do that loan for a time exceeding 30 days. Other individuals who are not the parents or grandparents would only be limited to that 30-day restriction. But keep in mind, with no clear definition of what express permission is, I would always suggest, especially if you are those other individuals, that you get you get some type of written permission or permission slip from the parent or legal guardian, because you do not want to be in a situation, and I think as parents we're kind of all used to, somebody's kid shows up at the house and they say, oh yeah, my parents said that'd be great if I played with your razor blade collection. And then, of course, the parents show up and they say, what the heck are you doing? I never gave him permission to play with your razor blade collection. The same would go here. I would not take just oral permission, especially if you're an organization loaning firearms to minors, or if you are a parent who's taking your kids and your kids' friends out to shoot. I would suggest going ahead and getting that written permission, and I'll kind of tip our hand here a bit. NRA and CRPA is making a free of charge permission form that's going to be downloadable at the CRPA website. We are in the final stages of finalizing that form, but the form is going to cover both handguns and long guns under California law and the handgun loan restrictions under federal law, and so that should give you the coverage you need for purposes of the restrictions on loaning. It's not a liability waiver or anything else attached to that. It is limited to and only to the loan restrictions and exceptions, and we're finalizing that right now. We'll put out a link to that, or we'll have a link to that on the CRPA website here within the next couple of days as we finalize that. And so anybody running youth groups and or, like I said, in the previous situation, if you're just taking your kids' friends out to either a range or to the desert to go ahead and shoot, you have that permission slip in hand, and so you don't have to worry about any issues concerning your loaning of the firearm to the minor. And then, of course, it actually covers the minor as well, because in a lot of situations the minor could then be prosecuted for either illegally possessing a handgun or a long gun under California law, and so you need to watch out for that one as well. And so it gives the minor coverage, and then of course it gives the person who loaned them the firearm coverage as well. Parents and legal guardians can loan a handgun, and now switching over to handguns to minor children if the minor is being loaned the firearm for, again, for a lawful purpose. And again, those are listed here. You got your recreational sports, you got competitive shooting, you've got agricultural ranching, you've got hunting. Since we are in California and Hollywood's not too far away from at least where I am, you have the motion picture, television, and the video production, theater, and provided all of those involve the use of the firearm. However, in those situations, the duration of that loan does not exceed the amount of time reasonably necessary to engage in that lawful recreational sport. And so the parent or legal guardian can loan their child that handgun for those limited uses. However, it's not a blanket loan exception. So as soon as that use is over with, that exception goes away. And so bear that in mind. And again, you still don't see here, for purposes of the parents loaning the firearm, anywhere it's required under California law that you have that written permission that federal law requires. And so again, in this instance, the federal requirement is more restrictive than the California requirement in that the federal requirement for handguns requires that written permission from parents. And so if you send Johnny or Jill out to the range with the handgun, under California you're going to be okay because the range is a contemplated use. However, without that written permission from you, you got yourself a little bit of a problem with federal law. So bear that in mind in moving forward. And so people who are non-parents, now switching gears a bit, who want to loan the minor a firearm, they still may do so under California law, but you have, as the small text would indicate, a lot more restrictions accompanying that exception. And specifically, the exceptions require you to either have the parent present or have that written consent from the parent or legal guardian. And so under California law, if you are running a youth sport and you have a handgun there for a minor to use, under California law, if that parent is standing over little Johnny's shoulder and you hand them the firearm and the parent says, yep, good to go, you're covered. Under California law, you still have that written consent requirement that's needed from the parent. And so in any of these situations, we're talking about the loaning of handguns under federal law, you're going to need that written permission one way or another. So any participants in youth shooting or youth sports involving handguns, you are almost always going to want to get that written permission one way or another, and it's just probably a good idea to have that and have that in your back pocket. So again, you are protected, little Johnny and Jill are protected when it comes to their possession of the firearm, and so we don't have any concerns with respect to either the feds or local law enforcement saying, hey, you gave that firearm to a minor illegally. But there are still a couple of other restrictions that are requirements that need to be met prior to you being able to avail yourself of this exception. Again, we see the limited use of that handgun being involved, and again, the same usual suspects I mentioned before, those youth shooting groups, competitive shooting, agricultural, you see the entertainment industry. The duration cannot exceed the amount of time necessarily to engage in those activities, as we saw before. However, in this situation, we see a further restriction in that you cannot have it exceed more than 10 days. And so in this situation, and unlike the previous one for parents loaning their minor child a handgun, you have a situation where if they wanted to loan the firearm to the minor child and say the hunting trip was going to last 14 days, then okay, fine. However, in this situation where if somebody is not the parent loaning the minor child the handgun, and as a result that hunting trip or whatever activity they're going to be engaging in exceeds 10 days, that's going to be a no-go when it comes to this exception. And so bear that in mind as well. For the parents, you've got a unlimited, albeit while the activity is going on, exception. For non-parents or legal guardians, you have a restriction for the duration of the activity. However, that activity cannot exceed 10 days. And as the note says, that minor should always keep that written consent with them, both for California and federal law, just to make sure that you're covered in both aspects of that. And so if law enforcement or if you're out there shooting and hunting on federal land, the feds show up and they want to say, hey, okay, where's this kid's permission to have this firearm? You have that all covered, and you just whip that out, show it. That should suffice for at least the minor possessing the firearm. If you've started a small fire or you've done something else inappropriate under state or federal law, they might want to talk to you about that, but at least for purposes of the loan exceptions and the restrictions, you're covered for those. California also has a restriction on just live ammunition for minors. A minor can't be in possession of any live ammunition. This is ammunition in all calibers, shapes, or sizes. However, there are a number of exceptions to that restriction. And again, you see the first thing off the bat there, written consent from the parent or legal guardian. That's why in that form I mentioned before, we have permission from the parent to not only possess firearms, and those being handguns and long guns, but the ammunition going along with all of that stuff. And so you'll see an exception or the waiver listing both of those, the firearm and ammunition, just to make sure the minor is covered for purposes of that restriction for the minor. Then, of course, you have a further exception either for the minor being accompanied by the parent, and then last but not least, or if that minor is engaged in one of those lawful activities listed below, they're going to be exempt from the live ammo restriction under California law anyway. And as I've mentioned, and I think I've mentioned it repeatedly now, getting that written consent will be the best and most sure way to go ahead and make sure you don't have problems in moving forward, while there are other exceptions for that minor being accompanied by the parent or that minor being engaged in one of those activities listed there. I would suggest having the written consent because you have something tangible, you have something that a law enforcement officer can hold in his or her hand when they're trying to make sure whether or not that child is in violation of California law for possessing that live ammunition. And so putting those two together, California and federal law, when it comes to the possession or the loaning of handguns to minors and the ammunition that goes with them, it's going to have to be limited to certain activities, and those activities are listed there, and I've mentioned them before: employment, ranching, target practice hunting, firearm training. You've got to have that minor or legal that minor's parent or legal guardians, provided they're not prohibited. But if you're a parent who's prohibited possessing a firearm and loaning that firearm to a child, you got more things going on, which is why I didn't mention it before. But nevertheless, the exception specifically requires that parent who's giving the permission to be not prohibited from owning and possessing firearms, but nevertheless, that permission needs to be written consent for the minor to possess the firearm or ammunition under California law, like I mentioned before. Live ammunition is restricted for the possession by minors. That minor should keep that written consent at all times while possessing the handgun and the ammunition. Multiple copies may be a good idea. And then last but not least, that duration should not exceed 10 days. That's a bit of a hybrid. Again, federal law just requires temporary. The loan of the handgun by the parent doesn't have a duration, provided it's so long as the activity is going on. However, if that loan of the handgun is by anybody other than the parent, you have that restriction for 10 days, which is why we've thrown that 10 days just to cover all our belts and whistles. It's hard to think that federal law would not consider something that goes up to 10 days as temporary. And so we have that covered. And as I mentioned before, CRPA will be posting a consent form that, again, youth groups, boys clubs, Boy Scouts, Girl Scouts, 4-H clubs will be able to use, and the runners of those programs, or again, parents who are taking the neighbor's kids out to shoot, you can have that written consent ahead of time, and most certainly you should have it ahead of time before taking those kids out shooting and enjoying the shooting sports. And so we're in the process of completing that form, and we'll have that available at the CRPA's website for you to download as many and as much as you please. So in summary, don't freak out. That loan restriction or the change to the loan laws didn't change everything. All of the other loan exceptions as they are to the California loan restriction are still in place. We had that one change to the personally known exception change and limit that exception to family members only with additional, of course, requirements. But nevertheless, all of the other exceptions that existed and that have existed under California law are still there. Your personal presence exception, while at a licensed range exception, the hunter's exception, and all of those exceptions I already mentioned for minors being in possession or being lent those firearms as well. And again, there are distinctions between both California and federal law, so it's important to keep all of that stuff in mind in moving forward. And if I've spoken too fast or didn't go into as much detail as you would have preferred, of course, this webinar is being recorded and can be re-listened to at the CRPA website. It will be added to the other list of webinars we have there. And then last but not least, and somebody moved it for me, thank you whoever did that, we are going into great detail on all of these exceptions and a lot of the other exceptions to the transfer restrictions on California firearms laws, or to California firearms laws, in the next edition of the book, which we will be finalizing here in the next literal days and hoping to have that available to the public here really, really quickly. And I also hear, I think Chuck might have rejoined us. And so that's about it for all of that.
Yeah, Joe, have a look at some of those last questions there while I answer a couple. First of all, there's a number of people from youth groups out there asking questions, and there are some nuances to this which we want to talk to you about directly. So send an email to contact@crpa.org if you're involved with the Boy Scouts or 4-H and work with a range. There are a few little nuances to the ownership of the firearms that are being used that we want to talk to you about directly and confidentially. Again, this webinar and all the other webinars will be available at crpa.org/webinars. So please go back and look at those again. You can see we've got the ammunition laws, we've got the assault weapon and ghost guns laws, and the false reporting and lending bills, and there's a lot of valuable information on those. For purposes of lending, I would love suggestions on how to optimize that form so it makes it easy for folks to CRPA and NRA want to do everything they can to support juniors programs. We do not want any law to stop us from being able to teach juniors and introduce them to the sport and to practicing the sport safely. So they've authorized us to do whatever we need to do to make it as easy as we can make it for ranges to access that form and access us to be able to keep those programs going. So if you have suggestions, maybe we can set that form up with some kind of a thing where parents can fill it in from their computer and then email it to you. We'll look into some kind of Adobe form program or whatever it is, but if anybody has suggestions on how to make it work better for your situation, shoot an email to contact@crpa.org and we'll take it under consideration. I do want to take a second and talk about this book. Right now, CRPA is offering a promotion on this where you give a donation to the CRPA and you get the preview, basically, of all the gun laws that will be covered in this book. This book should be out hopefully the beginning of December, but you can get the advanced copy of the preview of all the new laws if you donate to CRPA, and then they'll automatically ship you this book. So go to the CRPA website and you can get the details on that promotion, or watch for this book in the beginning of February. It'll have all that information. And I apologize that this thing has become an annual. I never expected I'd have to put out a new edition every year, but the California legislature is relentless. And so to keep up with all that, we have to. So if this is a way to make sure you stay out of trouble, We actually have another book coming out soon called The Gun Owner's Guide to Police Encounters, because unfortunately some of these laws are getting so confusing and so extreme that it's more and more they just trap innocent, law-abiding, wouldn't hurt a fly unless somebody attacked them gun owners, as opposed to the real bad guys, violent criminals or terrorists. Most of these laws are counterproductive, but I think this audience probably knows that. I did want to also cover one point that I forgot to mention about Prop 63. The laws that we're talking about today are going into effect, and the laws that were covered in the other webinars are going into effect whether Prop 63 passes or not. That's why the NRA and CRPA didn't put millions more into fighting Prop 63. They diverted that over to the president's race to try and keep the Supreme Court from falling into hostile hands, because there's only a few components of Newsom's Prop 63 that are different from the laws that Governor Brown signed, and we're looking for ways to show them how much we don't appreciate the fact that Kevin DeLeon, Senator DeLeon, and Governor Brown signed those bills, and Gavin Newsom promoted Prop 63. So please watch for the political action plan, which we are in the process of finalizing and will be distributing shortly after the election. Joe, do you see some questions? There's one about air guns and BB guns. Those are not firearms, so those aren't covered by these lending provisions, although there are different restrictions on BB guns that you should make sure you look up. Those are in the book.
Yeah, and I was actually going to address that one, and Chuck is correct. BB guns don't fall under the definition of quote-unquote firearm. I think for all intents and purposes, as there's no combustion involved in the discharge of the projectile. However, California law does have restrictions and does require parental consent for the loan or give of a BB device to a minor, and so you need that parental or guardian permission. I saw another question as it relates to the firearm safety certificate requirements. And no, in some of those exceptions I mentioned before, and specifically the personally present one and the hunter exception for the loan restriction, the firearm safety certificate is not a requirement. And as I've mentioned before, minors can't get a firearm safety certificate, and so that is not a prerequisite requirement for the minor loaning of that or lending that firearm to that minor, and so those do not require a firearm safety certificate. The owner being personally present when they've lent the firearm to a youth group, for then that youth group takes the firearm and uses it at a range, you got yourself a bit of a problem there in how many hands are transferring that firearm along. I would suggest in that situation that the owner of the firearm should be present and conducting the loan of the firearm to the minor. And so if someone is opening up their collection for the youth sports, and the youth sports are then using their firearm, and there's maybe a middleman or representative of that youth sport borrowing that firearm, the owner really needs to, unfortunately in this situation, make their way down to the range and be present for purposes of that, and so they could be said to be loaning that firearm to that individual. With that many transfers or changing of hands, it becomes problematic. I saw another question, although it's not covered here. I'll address it as well. There is under California law an allowance that long guns can be transferred to minors. That law is still on the books. However, as the people listening to this webinar may or may not know, there became a restriction on the intrafamilial transfer of long guns as of January 1st, 2014. And that restriction limited that transfer to those above the age of 18. And so there is a conflict under California law. One exception allows for a parent or a grandparent with the parent's permission to transfer a long gun to a minor. And in the other situation, it requires, if it's an intrafamilial transfer, that person to be over the age of 18. It's not entirely clear with those two code sections and their apparent conflict which one should prevail. My argument would be, since this one is specific to the minors the minor one should prevail for purposes of the minor transaction, and then when you have somebody who's over the age of 18 and you're doing intrafamilial transfer, that requirement and the registration and the firearm safety certificate requirements associated with that should prevail. That is not tested case law. No judges have chimed in on that. So be very careful if you're deciding to go ahead and avail yourself of that activity, and you may just want to wait, unfortunately, until little Johnny or Jill is 18 years of age, and then you can effectuate an intrafamilial transfer. But it does appear the way the codes are written that you can transfer a long gun to a minor child. And so I saw that question presented as well. That was the only ones I'd gotten a chance to get to. Chuck, if there's anything else you had saw or wanted to address.
No, the folks that are on the boards of Boy Scouts or 4-H or whatever, if you still have specific questions about your specific circumstances, shoot an email to contact@crpa.org, or you can email Joe directly. There's only about 4 or 5 of you, and we want to make sure that we get everybody comfortable so those programs can continue, because we'll do whatever we have to do to make that work. Those were the ones that jumped out. There was the one about black powder. Did we cover black powder? Whether or not that's a firearm depends on a few things. So you're going to want to look at the book on that one too, probably.
Yeah, because you have. I mean, these are type-specific long guns or handguns, or more accurately put, firearms that are not handguns. Firearm is defined for most intents and purposes to not include black powder, although California is a little odd when it comes to those. My assumption, and it would be something you'd have to follow up on and check in the book for, would be that they do not fall under these restrictions, but I cannot say for sure right off the top of the head. I apologize for that, but that's a little bit more nuanced than even I can get into really quickly.
One of the things that we may wind up doing for some ranges is making sure that they have an FFL, even if it's just for basically loaning for samples, kind of things. Again, if this webinar didn't answer your questions because you have some unique circumstances, give us a buzz and we will do what we need to do to make things work out for you. Other than that, I think I've about covered everything. Once again, I'd reiterate that with all his flaws, Trump is going to put pro-Second Amendment judges on the Supreme Court. Hillary Clinton is going to put judges that have already voted. She will pick from amongst the judges who have already issued opinions that really limit, if not in many respects eliminate, the protections that the Heller case gave us through the Second Amendment, confirmed that the Second Amendment gives us, I should say. So for all his flaws, he's really the only choice if you believe in the right to keep and bear arms. I think that's it. I don't see any other questions coming through right now, so I want to thank everybody for your time. I hope you'll get involved in the fight. Join NRA, CRPA, and promote them to the extent you can, and keep getting those kids out to the range. They're our future. They're the future of firearms freedom. We want to do everything we can to continue to help those programs happen and to help the next generation learn about how fun and valuable our firearms freedoms are. So with that, I think thanks everybody, and watch for our next webinar. I got some questions on gun trusts. There's a gun trust webinar in the works, and these are very popular, and so we're going to have a number of these coming out just as quickly as we can get them ready. So thanks again, everybody, and if you missed any of this, watch it again on the CRPA website. Thanks.
And thank you, guys. This is me signing off as well. Those hundreds of you still in the chat and the thousands of people who have signed up for this webinar and will be listening to it later, thanks again. And keep up to date with CRPA. We'll be, like Chuck says, be doing a number of these later on. And again, of course, we go into greater detail in the book on a lot of these issues. And last but not least, as Chuck said, if you have any questions or concerns, feel free to reach out to CRPA or our office concerning specific questions, and we most certainly will be happy to address specific issues depending on the situation. So take care, everyone. We'll keep, as we always do, the chat room open. If there are additional questions, I don't think, again, we're going to do a frequently asked questions as we did for the previous bills, but they do help us, truth be told. because if you have a question that we may not have thought of, I'm not an arrogant enough attorney to think that I know the answer to everything or all the questions and nuances that I've contemplated are all there is. They do help us flesh out our book and a lot of the areas that we need to respond to or consider in lawsuits and things along those lines. And so we'll leave the chat open. If you have additional questions, go ahead and put them there. Again, and I apologize, we're not going to be able to address them, but you may somehow see your question sneaking in to the book as a paragraph or a sub-chapter when it comes to these issues. So thanks again, everybody. Take care. I'll talk to you, I'm pretty sure, pretty soon. Bye.